Hello and welcome to today's webinar that is co-sponsored by Atos and Digital Guardian, a practical approach to GDPR featuring IDC's Duncan Brown. I'm Ann Scholl with Digital Guardian. I will be your moderator today. For our agenda, I will briefly cover logistics. Then for the lion's share of today's webinar, Duncan Brown will talk about IDC's practical approach to GDPR. Then Zeina Zakhour will talk about the Atos approach to GDPR, after which we will leave 10 to 15 minutes for questions. Throughout our presentation, I encourage you to submit questions that we will answer at the end of our presentation. We will begin taking live Q&A at the end of the session and will answer as many questions as we can, given time constraints and the expertise of our speakers. If your question is something better left answered by someone else on the team, we'll follow up with you directly. We will also be emailing you both the recording as well as the slides of the webinar. And now it is my pleasure to introduce our featured speaker. Duncan Brown is Associate Vice President, European Security Practice at IDC EMEA and leads the firm's security research program in Europe. Brown's expertise spans the gamut of security topics including incident response, threat intelligence, and global privacy issues. He established and leads IDC's coverage of the global impact of the GDPR, the e-privacy directive update, and the NIS directive on technology companies and their customers. And now I'd like to hand it over to Duncan.
Thank you, Anne, and good morning, good afternoon, wherever you are tuning in from. So we're going to have a whistle-stop tour through some of the key aspects of GDPR. But what I have picked up over the last, I guess, 3 or 4 months, so probably since the beginning of the year, is a change in the types of issues and questions that organizations are raising. I guess maybe 12 months ago, we were looking at, what is GDPR and why does it matter, and does it really apply to me? Those kind of questions. I think in the last 3 or 4 months, we're now seeing very detailed and pragmatic questions and concerns. And that's a demonstration that people are really thinking about, okay, this really does matter. Now what do I have to do to that to get compliant? So what we thought we'd do today is to really drill down on some of the pragmatic concerns to GDPR compliance. We'll share with you some of IDC's thoughts, and then Zeina will talk about some of the practical approaches that Atos and DG are applying as well. So let's get stuck straight into it. And I guess the first question is, why are we here? Why should we bother? And what makes GDPR different to other security or data protection standards and regimes that we've seen previously? Well, the short answer is that it is all about risk. GDPR represents a substantial increase in business risks that elevate it to a level consistent with, for example, anti-money laundering or anti-bribery and corruption legislation. In other words, it's designed to change behavior of organizations processing personal data. Let me just give you 4 quick reasons why I think this is the case. The first is, well, everybody talks about fines, and there's a lot of wishful thinking about fines and the application or lack thereof. Look at the regulation. It says fines need to be effective, proportionate, and dissuasive. Again, they're designed to change your behavior. So that's why I have every confidence, and I've spoken to several regulators across Europe, I have every confidence that fines will be levied. I have to say you probably have to try really hard to get a 4% fine, but nevertheless, fines of up to 4% are absolutely on the agenda. But it doesn't stop there. In fact, if you speak to board-level members in organizations, they are actually more worried about mandatory breach notification. So this is the Articles 33 and 34. Really concerned about the consequential loss of reputation to businesses, which is actually, it takes much longer to repair than a one-off fine. So boards are really worried about that. The skeptics amongst us, even though you think, oh, we won't get fined, and yeah, we can recover from reputational damage, well, you may not recover from a class action lawsuit, which is made possible through GDPR. So it's not called class action lawsuits, but it's in there. and that's effectively what they are. So individual data subjects can take an organization to court for non-compliance, not just a data breach, but any sort of non-compliance. But not-for-profit organizations or associations can represent multiple data subjects on their behalf, and so effectively you have a class action lawsuit, and that clearly sits outside any action that a regulator may take. And then finally, and this is tucked away in Article 58, so I have the reference there on the slide for you, but in extreme cases where you really try not to comply, they can essentially suspend you from processing personal data. What does that mean? Well, if you process customer data, then you can't do that, and so that would probably put you out of business. If you are processing citizen data, then similarly, personal data, you can't do that. You can't even process employee data like the payroll, because that's personal data too. So there's a pretty big stick at the end of the process if it all goes really badly. And so collectively, these four big sanctions, and there are several others within the text, but these, I think, are the big four ones. So they collectively mean that the risk shifts, and that's the motivation that organizations need to start doing things differently. So if you want to borrow the slide for your business case, take that to your board, then I'd be delighted to be my guest. So where are organizations now in their readiness? So we've just done some research recently, so let me share with you the overall results. So basically, this is showing how organizations are kind of mapped into the readiness of GDPR at the moment. And it's a pretty much mixed picture. The way I would characterize this is by saying that just under half, 43% of organizations are today in a pretty good place. There's a solid plan in place, or you're ready now. And good for you. I'm not entirely sure whether that is a measure of comfort or possible complacency, but hey, we've got to take people at their word. So let's say 43% of our sample right across Europe is compliant or expect to be there in a year's time. Unfortunately, there's just over half of organizations by definition, therefore, are not ready, and by my estimation will really struggle. So organizations, you can see the bulk of organizations are saying that they will start addressing it this year. Our estimate is that conservatively this is an 18-month project, and by definition, if you start now, then you're going to really struggle to finish on time by the 25th of May next year. And organizations that don't know where to start are waiting for further guidelines. I would say you need to start now. There is enough in there to get started, and so this is kind of the focus of today's session, to really focus on where you can start and where you can get good benefits today, and as things become more clear over the next 6 to 12 months, you can build that into a program, but there's plenty to be getting on with at the moment. So one of the big questions that we get is who should lead this program? And this is a really interesting question. So let me share with you two views on this. All of our research sort of boils down to two key points about GDPR leadership. The first point is that it doesn't really matter where the leadership comes from. So our survey shows that a big chunk, 40% or just under, come from corporate management. IT, interestingly, that includes security, so we bundle a CIO or a CISO responsibility into that 31%. So that's a big chunk of people. The next big chunk, not surprisingly, is legal, and then various other places, finance, accounting, and so on. Our evidence shows that it doesn't really matter where that where the program is led from, as long as it is led by someone. That's the first key learning. The second key learning is that whatever the leadership is, wherever that comes from, you must have a cross-functional task force that oversees it. You've got to get all parties, all stakeholders involved. And the not so good news is, according to our survey, only just over a third of organizations have done that. And there's a huge risk in doing that, because if it's led by corporate management and you haven't got the individual stakeholder members from IT, from legal, from compliance, from sales, marketing, human resources, etc., then it's almost destined to fail, because it becomes a siloed project that affects someone else. And GDPR affects everybody, internally and externally facing. And so the big learning from this is organizations really must focus on this cross-functional task force or governance board that oversees and gets involvement from all stakeholder parties in the organization. Otherwise, it is doomed to failure. So one of the other things we get asked about a lot is, what is this data protection officer role? How does that come about? There's a lot of myth, a lot of uncertainty about whether we need one, whether who should play that role, and those kind of things. So I just want to give you a quick few points on how we are seeing this. And in fact, the Article 29 working group, which is the kind of the club of regulators, issued some guidance on DPO constitution and the role. So that's useful to look at. It's on the Article 29 working group website. So what do we think? So firstly, DPOs are mandatory for public bodies. So if you're a government or government-backed organization, then you must have a DPO, no questions asked. And also, if you are not a public body, but so you're a commercial organization or not-for-profits or third sector organization, if you are processing large-scale volumes of data on a systematic basis, and particularly if you are processing sensitive data, so that's the special categories of data, so biometrics and gender and ethnic information, that kind of thing, then you are obliged to appoint a DPO. I think it's also worthwhile to look at, even though you don't fall into those mandatory categories, whether it's actually a pretty good idea to do this anyway. The regulators have indicated that, you know, if you have an incident, a substantial incident that attracts their attention, they will ask you, do you have a DPO? And you need to have a pretty good reason for not having one. And so as a risk mitigation exercise, you might actually look at appointing a DPO just because it represents good practice. It's not mandatory, but it's certainly good practice. So do have a think about whether you should do this just as a matter of course. It applies both to controllers and processors. So one of the big shifts in GDPR is the extension of liability from just controllers, as we have under the Data Protection Directive today, to include data processors as well, so third parties. And the regulations for data protection officers apply both to controllers and processors. So processors are on the hook for liability, but they're also on the hook for things like, do you have a DPO in place? So if you're on that side of things, do have a look at the requirement. You can't just appoint someone, you know, a low-level person, the janitor or the receptionist, to do this. It's got to have someone that has, quote, expert knowledge and ability to fulfill the tasks. Not necessarily a lawyer, although that might help, but certainly someone who knows their way around the GDPR and the broad data protection space. So think about that. Importantly, it does not have to be a full-time in-house employee that performs this task. It could be a part-time role, or it could be an external service provider, so through a contract. And we know that some legal firms and consulting firms are looking to provide data protection officer as a service capability to data controllers. So that is an interesting prospect to look out for. Importantly, no conflict of interest. This was a big area of focus in the Article 29 Working Group guidance. You can't have a conflict of interest, and if you think there is one, then there probably is one. So, for example, an IT director that is making decisions on the processing of information, and that would include whether to use a third-party cloud outsourcing company, for example, that is assisting in determining the purposes and means of processing. That probably would represent a conflict of interest with the roles of a DPO. And so CIO, Chief Legal Officer, possibly, also a conflict of interest. So it's really important to think through the possible conflict of interest areas in that regard. And finally, you can't fire them for performing their duties. So they are essentially untouchable for doing their role. They're designed to be kind of the insider auditor, if you like, a whistleblower when things go wrong. Let's hope it doesn't get that way, but they are the direct channel between the organization and the regulator, and so are protected in that way. Now, I mentioned the in-house versus external idea, and actually we asked this question in our survey, and what's interesting is that most organizations intend to appoint someone from within their organization, and that's to be expected, but it's just over half of organizations that are looking to do that. Just over a fifth already have a DPO in place and are presumably smug about that. But over a quarter of organizations are looking at a variety of other sources. So we'll look to appoint someone from outside or using a contract resource, and only 7% of organizations expect not to appoint a DPO. So if you are in that category thinking, well, I don't really need a DPO, you're in a substantial minority. You're in a very small minority there, and so actually it's probably worth just thinking that through on a complete basis. So that's about kind of the leadership and the management roles on GDPR. I want to shift gears somewhat and look at one of the other key questions, which is to do with the technology that one needs to look at in order to be compliant. This is a really interesting area because there's a lot of activity going into the process, into the legality, into the outcomes that we're trying to achieve through GDPR, but there's then a bit of a gap between, okay, we know what we want as an outcome, but what technology do we need in place in order to deliver that? And organizations are really struggling with this. So we've come up with this kind of three-step framework that I hope you will find useful. I just want to run through that. So 3 steps, so 3 broad areas of technology, and I'll go into these in a little bit more detail in just a second. So information governance, that's kind of what it says on the tin. It's getting a handle on the data that you have in your organization. The second layer is looking at technology support for very specific requirements. So over and above the kind of the general information governance, what is it specifically in GDPR that needs support through technology? And then thirdly, but certainly not lastly, a review of state of the art. Now I'll explain when we get there why we use this term state of the art. Okay, so let's look at information governance. So this is all about what personal data I have, where is it, how sensitive is it, why do I have it, what consent do I have consent for one purpose but not another, how long can I keep this data for it, when do I have to delete it, can I delete it, and all that kind of stuff. So what's interesting is there's a whole range of approaches to get there. I think the first thing one must do in a GDPR program is understand what data I actually have in my organization. And I don't know why I'm still surprised, but I'm still surprised at the fact that many organizations, hand on heart, really can't answer that question to the degree of completeness that is required by GDPR. They say, well, we kind of know where most of our data is. Well, most isn't all, and all is the requirement under GDPR. So I recommend you do something like a data visibility assessment to really understand what data you have, where is it in the organization, why you have it, can you get rid of it to reduce your liability, if I have to hold on to it, for how long, why am I keeping it, and so on. So really get a handle on the data in your organization. I think also what's clear is that although technology alone will not make you compliant with GDPR, you cannot be compliant without technology. There is so much in there, certainly at any degree of scale that you're operating at. You must look at automation of some elements of your GDPR process, because to do it manually is ultimately to fail. You cannot conceive of doing this at any scale without automation. That's really important to look at. And there are a number of key technologies here, but again and again and again we hear DLP, data loss prevention, coming up. I think that not all DLP solutions are the same. So I think, for example, you're looking for real-time classification. So as you try to send some information out of the organization, there's an automated classification. So it's actually looking at the documents that you're sending out, and protecting data not just in a static format, but also in transit. So I think that's a really key technology that organizations are looking at, and it's almost seeing the resurgence of DLP as a technology. It's perhaps not the most fashionable, or hasn't been the most fashionable to date, but it's right back in fashion right now. So DLP is having a bit of a boom, as you might imagine. Okay, so that's the broad information governance space. In terms of meeting specific requirements, there are a number of those. So right to be forgotten, RTB, sorry, that's my shorthand, but things like consent, encryption, DLP, if it's not covered at information governance layer, definitely should be in this layer. Data portability, that's an interesting conundrum that organizations are faced with, access control and the rest. There's a whole range of technologies. So I just wanted to call some of those out. So data discovery, classification, control, absolutely fundamental. Again, if it's not part of the information governance piece that you're implementing, then you must get to it through the specific requirements. Access control and identity management and privileged user management, let's treat those collectively. The unauthorized access of information is a primary source of non-compliance for organizations. So this is what would ultimately result in a security breach, so not necessarily a data breach, so no data has necessarily left the organization, but someone who doesn't have authority to access it is accessing it. And in fact, this would include ransomware, because that's an unauthorized access to data. You don't have to steal data to corrupt it or to destroy it. So this as a ransomware attack, such as we saw a couple of weeks ago, would be included in this. So access control, identity management, and privileged user management to look at insider threat, for example, are fundamental to GDPR compliance. I've mentioned encryption as well. Encryption isn't mandated by GDPR, but there's a pretty heavy hint in there. Article 32, the security article, and there's a very heavy hint there that encryption is a pretty good idea. Needs to be done with care. That's a longer conversation, but it's definitely in there. And then things like auditing forensics, really important to be able to evidence the fact that you are compliant. It's not enough just to be confident that you're compliant. You've got to be able to evidence the fact that you are trying hard. That's one of the key things that the regulator is going to be looking out for. So your ability to do auditing when things are going well, and forensics when things didn't go so well. Really important to understand why they didn't go well, what forensics do you have in place to determine that. And the regulator will take a very benign and favourable view of an organisation that can demonstrate that. And then we get to breach detection and notification. Really important when you have a breach to detect that early. And then obviously you have to be able to notify the regulators within 72 hours and data subject. Well, in fact, there's no time scale for data subjects, as soon as feasibly possible. So really important to be able to detect early. Regulators will be looking out for that. And then this idea of managed services, I think the volume of stuff that is going on within a GDPR program really does call out for some specialist expertise, particularly in breach detection or incident response, for example. But do look at the possibility of outsourcing some of this to a managed service just to get you there by May 25th, 2018. I think that's a really important thing to consider. So that's the second area. And the third area is state-of-the-art. So state-of-the-art is mentioned twice in the article. It's mentioned in the security article, number 32, and also in the data protection by design and by default article, which is 25. And it basically says you should have appropriate technical and organizational measures, and it says you should have regard to state-of-the-art, taking into account state-of-the-art. Now, you're not obliged to have state-of-the-art, but you need to know what it is, because you will have to defend your position if things go wrong. So the things you need to look at is what is state-of-the-art. You need to come up with a definition for that, or organizations, dare I say, like IDC, will help organizations in their assessment of state-of-the-art. But then looking at that in the context of your organization, so looking at the cost associated with state-of-the-art technologies and the risk, so looking at the data and the types of data and the sensitivity that you hold in your organization, and then what I call context, which is a bunch of other stuff, so the geographic distribution of your organization, the size, the amount of data that you're processing, and you know, basically everything else. So you've got to balance these four things, that your understanding of state-of-the-art, cost, risk, and context, and then come up with a decision that you can defend potentially in the court of law when it all goes badly wrong. So it's really important to get a handle on state-of-the-art and also to document what it is, why you came up with that view, and the decisions about whether or not you've implemented state-of-the-art. So really interesting debates to have internally, as you might imagine. Okay, so very quickly, where to start? This is the big question. The process here is, well, you probably should have started already. I'm guessing that most people on this call probably have started their program of sorts. Now, maybe not actually got to the technology part already, but you certainly should have your management framework in place. So whoever's leading it is great. Have this cross-functional department, cross-department governance board in place. If you don't have that, get it in place now. We reckon that you need to be doing this discovery process, well, more or less as we speak. I'm probably looking to finish that over the summer, and then you get to what we call an assess phase. I'll explain what these phases are in just a little bit more detail coming up. But we reckon that that should be finished probably by the end of the year, to be able to then start implementing technology probably by, well, certainly starting this year and hopefully finishing with a month to spare in April. Now, obviously that's a bit tight, but you know, we are where we are. So if you obviously contract these timescales, then great. But that's kind of what we're seeing, what we're advising clients to do based on kind of where they are if they were starting to go now. And then I think importantly, moving forward after that, looking to continually comply. So this idea of continuous compliance is really important. And you know, GDPR just doesn't stop at May the 20th next year. It's a continuous program. So managing compliance sort of carries on. So I said that I'd very quickly go through the manage, discover, assess, and review or protect phases. Just let me very quickly go through this. So I said, select a leader. This idea that it's a program, not a project, is really important, and I think I've said the stakeholder engagement point several times already. This idea of discover, getting visibility on the data that you have is essential, and then mapping out a sense of risk exposure to that data, and even taking decisions whether to delete data or certainly move it offline if it represents substantial risk. The thing that this provides is the assessment of the scale of effort that you are faced with. And organizations really need to get a grip on that, and then ultimately, I guess, prioritize based on that scale and the associated risk. The next phase, assessing, really what we're talking about here is assessing the role of technology. So having that three-phase model, so information governance, specific requirements, and state-of-the-art. Impact assessment. So impact assessment is really important in context of GDPR. So data protection impact assessments must be done when you are changing technology that touches personal data, or rather you've got to do an assessment to determine whether the impact is great. So you have to do an assessment to know whether you need to do an assessment. It's kind of one of these strange things about GDPR, but a really important thing to look out for. Data protection impact assessments. And then finally, look at the organizational behavior changes that you're looking to effect within your organization. GDPR is designed to change organization behavior, so expect that to happen. And then finally, you need to conduct a constant process of review, particularly in, we think, access control, and then data control, so looking at the data protections that you have around your data. And last but certainly not least, if it goes wrong, how do you respond to an incident? What's your breach response protocol? So hopefully that's been useful. As a whistle-stop tour, I can see questions coming in, so we'll take those right at the end. So thanks for those. Keep them coming. I just want to highlight that we've produced a lot more detail than I've been able to go through this afternoon in an executive brief report that is available. I'm sure we'll be sending you details on how to get access to that in the follow-up. So do look out for that. There's a lot more detail in there. But for now, thank you very much. Keep your questions coming.
Thank you very much, Duncan. Next, I'd like to introduce Zeina Zakhour, Global Chief Technology Officer at Atos Cybersecurity, creating innovative solutions to be a step ahead of cyber criminals. Zeina covers the end-to-end spectrum of cybersecurity, from security advisory to security integration, managed security services, and IoT and big data security. She worked closely with Fortune 500 companies to advise them in their security strategy and secure their infrastructure and protect their data. She's a certified information systems security professional, CISSP, and a certified ISO 27005 risk manager. Yet she believes that when it comes to cybersecurity, we never stop learning. And now it is my pleasure to hand it over to Zeina.
Thank you, Anna. Hi, everyone. And thank you, Duncan, for your insightful presentation. So indeed, what we wanted to do really in just 10 minutes to give you a quick introduction about how we have been working with our customers to building a data privacy program in a pragmatic way. One of the key topics that Duncan mentioned is that we have a lot of factors involved in GDPR. It's a program. It's just not a one-shot. But also one important thing is that we need to understand what is expected from GDPR. We need to be as exhaustive as possible from the start. So we all know we have only 1 year now to be compliant, but it doesn't mean that we need to move ahead quickly, that we have to go with a gap analysis only focusing on what we believe is the key service or business unit or database where personal data is processed. So there are some questions that are important to ask to understand what is the personal data, who's accessing it, and how is this data used and exchanged, to identify what are these non-compliance risks. So we've mentioned the DPO, the Data Protection Officer. but also that this person have a clear visibility of all the personal data life cycle. It's not only about assigning a role, it's really about giving this person the necessary leads and to be able to do his or her job. Another thing is important is about really raising awareness through all business lines. We've mentioned the data consent forms, we've mentioned the right to be forgotten, all these topics, even data minimization. This is the business line that's going to actually have to take these into consideration and to understand why these requirements are important. Another important question that we need to ask ourselves is about cloud services. Most of organizations have subscribed to at least one, if not many, cloud services. So how is the personal data processed through these cloud services? There are a lot of questions that are important about really the first step of understanding where to start, but also about how to implement these controls. What are the requirements in case there's a data breach? How should we get organized? How should we notify the national authorities, but also the concerned victims, the consumers, your customers? And one important thing is how can you really demonstrate compliance with the organization? So as you've seen, there's a lot of questions, but there are answers to these questions. What we've done is that we've built a 5-step program that uses a continuous improvement cycle to deal with these wide-ranging impacts of GDPR. Duncan said it's not about just being compliant once, it's really a journey. And we need to make sure that these steps that we're going to do will actually be updated throughout time. So what we have recommended is really to start, and it's really aligned with what Duncan said, with a data protection impact assessment. This is a key requirement actually in the GDPR, but to do this DPIA, there's also a need to have a personal data catalog. We need to understand where are these personal data, and then to do this impact assessment to understand what are the risks that exist and that falls, and then to be able to understand what are the controls to implement. So in terms of DPIA, there was a lot of question about, okay, what is the methodology we should use, when should we apply it or not. So the EU Working Party, WP29, issued in April a recent draft guidelines that you can check online, and it's very useful because it helps you understand when should you actually do a DPIA or not, and also gives recommendation in terms of methodology. There is no methodology defined in GDPR. However, there's already a few countries like UK, Germany, France, and Spain that have already had guidelines about how to run this impact assessment, and it's very important to understand when it should be run and also to regularly update, because there's no one solution that, especially in IT, that is implemented and never changed. There's always continuous improvements, new add-ons that are done in the infrastructure and in your business line, and it's important to update this impact assessment. Also, it's important to understand that when we're talking about security, the threat environment changes constantly. So this update of the DPIA is important because the risk will change. Another key step is GDPR governance. This is very important to be able to understand what are the organizational and technical controls that we need to implement, but also how are we going to manage our data processors, so these subcontractors, this outsourcers that we're dealing with. It's important to be able to understand what are the requirements. So as Duncan said, now for GDPR, the responsibility falls on both the processor and the controller, but it means that you will need to review your contracts, you need to update them, you need to put new SLAs for GDPR compliance to be sure that you have this auditability of data flows and access to these critical data that is personal data. A third element in our approach is really the business processes update. It's very important. It is not related to security per se. I'm a cybersecurity expert, so I must tell you this is not related to, it's not a security control, but it's a very important step to do. And this is how we actually in Atos, we can work with our customers in order to help them understand how they need to change the way that they are interacting with their customer online. These consent forms need to be updated. It needs to be explicit. The data minimization principle that you need to clarify what data you're going to use and how you're going to use it and for what you're going to use it. So there are a lot of changes to be implemented. Just also this, not only the right to be forgotten, but just the right to ask, how are you using my data? And to be able to answer and reply in due delay. So all of this information or questions from your customer, you should be able to answer them, at least your EU customers, let's say. And then we get to one important step, which is the data protection. Really, how are we going to implement and what type of controls? In the GDPR, there are clear guidelines about what are the access controls that you need to implement to make sure only authorized people access, to give what we call the least privilege apply the least privilege principle. There's clear recommendations, for instance, around data encryption, around security monitoring, continuous auditing, to make sure that really whatever we have identified as the risk and necessary controls to secure the access and be able to actually generate necessary reports and visibility on who's accessing it. All this is working over time. DLP is data loss prevention is a very interesting tool because it's not only it allows you to make sure that only authorized people have access or usage of the data, you make sure that the data is not going to be stored where it doesn't belong, and this is very important for the GDPR and personal data. And then, of course, there's an important thing is you need to be prepared whenever there is a data breach and how the personal data breach notification is going to be processed, and specifically how the incident response is going to happen, about how we're going to identify what's the reason. And there are also some interesting elements in this article around encryption, where they mention that, for instance, if you have implemented controls that actually makes the personal data unusable, if in case of a breach, there's no need to do any notification to the concerned end users. This is, I think, in Article 34. So there are a lot of guidelines, and also this will help you understand what are really not necessarily mandatory, but the best options to implement. Now, if there are, of course, security experts on this call, you will say that this is what we might call the best practice. This is nothing new. We understand that we need to put in place, I'm talking, of course, about the data protection controls per se, but not organizations have implemented this type of controls for a simple reason that sometimes you need to wait. Is it really good to have or must have? And here, this is where we're changing, where we're going really into must have in order to be compliant. As I've mentioned before, the first step to launch your GDPR program is to understand where is your personal data. Going with assumption might actually make you waste your time and also miss some important information. So what we've done with the Digital Guardian is that we've implemented a readiness assessment program approach. It's really just a 30-day software-guided data security consulting assessment. It's about helping organizations understand a quick scan, let's say, and understand where is this personal data in my organization, how is it used, because you have the option to check only the data at rest, so where is it stored? If it's on some cloud storage, where of course it shouldn't be. Is it in secured in the database, on some network shares or file repositories? And also it's about data in motion. How is this data in use? Because it's very important to understand that personal data also of your customers should not be sent through emails if this is not really part of the actual and documented data processing activity. So the advantage with this approach is that it already gives you a clear visibility of what's happening in your organization. We have out-of-the-box policies. We can create specific policies depending on the type of data that we want to identify. If we're talking about credit card data, different type of personal data, and then to able to understand whether there's any incident. It means that do we believe that there's a data that's actually being sent through emails and this type of data that has no need to be sent outside the organization? Is this data being shared on STP, for instance? Also, we can go and check where the data is located. Is it located on some cloud storage, for instance? Definitely not to do. Is it really in the database, appropriately secured, controlled access? So this approach will really help ease the process into understanding where is the data and whether there are any high risks threats fall on this data that has been discovered. One key element that we introduced before is now really the shared responsibility of the data processor and the data controller. And this is why we mentioned it's very important in the GDPR governance. You need to understand who are your partners, who are your subcontractors, who are your managed service providers, integrator, and that you need to make sure that these have now a culture of data privacy as well. If you're hosting the data with these processor, you need to make sure that they are only accessing the data as required, as documented, and there are clear controls and reporting that has been put in place. So you see, we've mentioned here a technology catalog. It's just a list of the technologies that could and are recommended. But the important thing is really to understand this is not only about technology. Of course, technology is one key element of it, but also it's about governance, it's about defining SLAs and KPIs, and really be able to have a data catalog that exists and that can be used in order to understand how the personal data is used in your organization. So there was a question earlier about what type of technology solution we should implement. There is no out of the box. So if what you've seen here doesn't mean that you need to implement all of these solutions. This is why we insist it's not only a technology. There's only one answer through technology. We need to understand what are your personal data, where is it stored, who's accessing to it, do this DPIA, and then be able to understand by doing this risk assessment what are the risks and what are the security controls that need to be implemented. So I mentioned earlier that we wanted to share with you some example of what we've done with our customer, and this could be a good place now to start doing it. For instance, we have a customer that wanted to understand where do they sit in terms of securing the data of their end users. Recently, I think it was 1 or 18 months ago, there has been a big data breach. Every day there are data breach, but this one that we see the CEO of this company on TV, and the CEO couldn't positively say that they encrypted the customer data in the event of a data breach. It was a question, and the CEO said, honestly, I don't know. So the board of this company, the company that reached out to us, is telling them we do not want to be in the same situation as this company. We really want to say that we have put the necessary controls and to put this data privacy, and now it's called GDPR compliance, on their board item, and to be able to have regular KPIs on this topic. So we've worked with them to do this readiness assessment and identify where is this personal data and which customers this personal data is stored and how is it used. And then depending on the database that supports each of these applications, we actually help them understand what are the solutions to put in place. And one of the solutions was, for instance, the encryption of the database. It was the best approach to put in place. We also recommended installing access control. For instance, we have our own technology, Evidian, that we've used in order to define clear access sites, personal access sites, role-based, defined depending on the role of the user, and that actually will provide a lot of traceability. So this is just a few examples of what needs to be put in place in order to secure the data. To have a reporting, an appropriate dashboard on this compliance, and also to be able to say we are ready. Any organization that today says we have never suffered a security incident, it's just simply they are not aware of it. Security incident doesn't mean that data will be stolen and that you will have hundreds of terabytes that have been stolen from your organization. It just means that you are able to identify an attempt of intrusion. The faster you identify and the faster you react and neutralize this attack, the better you are. And this is what organizations today need to organize themselves for. And this is what we call, so it's just an example of a few technologies and solutions that are today implemented in an organization. However, the mistake that some might do is that consider each of these solutions are standalone solution, which should not be the case. So if you're going to implement a data loss prevention solution, it should not be just about, okay, I've defined the data policies, and then it's going to run on its own. Maybe there's some admin team that's managing it, and that's it. It should actually be part of this integrated and intelligence-driven security management, where all this technology that you see at the bottom are actually communicating together through the centralized, what we call Atos high-performance security, which is like a SIM++. And then be able to have a security operations center and an incident response team that are ready to detect in real time any misalignment, misalignment with, for instance, the access control that we have put in order to protect this personal data, and to be able to immediately react and contain this problem. And this will give not only visibility, but also with this capability to say we are compliant because we see what's happening. We have actually auditability capabilities. Our report will tell us who has access to these personal data, and if the unauthorized users try to access it, they potentially will not be able, since we've put the necessary controls. But even if they try, we will be able to get a report and a visibility on this topic. So what we say about GDPR compliance is that really it's a journey toward a secure and efficient data management lifecycle. But really you should see it as a business enabler. It's going to increase your customer loyalty. When customers see that you're managing their personal data securely, that you've put in place necessary controls, they will have more trust in your organization. But in order to start this process, there are some key elements and recommendations that you would say. You cannot protect what you don't see and what you don't know about. This is why it's very important. This data catalog, this visibility and readiness assessment are key and important so that you know where is your data. You need to break the silos. Security teams should work with data protection teams, should work with the business lines. A whole organization is concerned by GDPR or just by data privacy program. So we need to break the silo. We need to make sure that everyone has been educated about the importance of data privacy, about the controls that needs to be put in place. Another key important recommendation is to adopt purpose-driven data collection. Just collect the data that you need in order to run your business. This is important, this is a requirement, and it's what will make you as close as possible to the compliance, because you know that you've only collected what is needed. You've been very clear with your customers of why you are collecting this data and how you are using it. Think about the extended enterprise. It's not only about a database. It's not only about the file repository. How about your supply chain? How about your partners? How about all this ecosystem that you're connecting with, that sometimes has access to your environment? And this is very important as well in terms of who's accessing your personal data or not. Auditability is important. A controlled data processing approach is key. When we know who has access to what and why and when, and are able to generate reports on this will make us as close as possible to the data, to the GDPR compliance. Update your risk assessment matrix. It's not a one-shot. The DPIA is not a one-shot. A security risk assessment is not just something that we do once now until we launch the GDPR and then we forget about it. It's very important to run this update regularly. And one thing that's important is that the challenge is not only to be ready by May 2015, but to remain compliant afterwards as well. Thank you everyone for listening to us, and now we're going to start taking your questions.
Thank you, Zeina, and thank you to our audience for posting great questions. We are coming up on the hour, but we're going to stay on a little bit longer to get to as many questions as we can. So the first question that we have, how does GDPR affect EU data in non-EU regions?
Who's that for? And is that for me or is that for Zeina? I have opinion on anything, so.
Yeah, I'll just ask them to both of you, and then you can each answer or both answer depending on what you think.
Sure. Okay. So I'll give Zeina a bit of a rest, and so let me give you a very quick answer to that. So the short answer is that the regulation applies to the subject of the data subjects, and whether they are in the EU. It's irrelevant where the processing is conducted, and it very clearly states that. So for organizations that are not based in the EU, but are processing data relating to people in the EU, then you're in. There's a question about jurisdiction that's coming up as well. So, I mean, we could probably address that at the time, but that's the broad rule. So this is why GDPR is being described as a global regulation, because it has this extraterritoriality aspect to it. So the regulation follows the data subject. It's irrelevant where the data processing is conducted. So, you know, hypothetically, if you're a US company but dealing with EU data, then you are captured by this. That's a very short answer to that. There's lots of nuances as well, but that's the broad picture.
Okay, thank you. The next question is, can the software detect personal data from SAP?
So I will take this one. I think the question is really concerning DLP and Digital Guardian. And yes, of course, Digital Guardian is capable to manage data and to put security policies to data throughout the environment of the organization, including SAP.
Thank you. The next question we have, what is regarded as large-scale data processing, RE DPO?
Yeah, I thought this might come up. So I can only refer you to the Article 29 Working Group DPO guidance. But there are a couple of examples in there. So first of all, it's vague, and the guidance doesn't actually make it much clearer, but it does give examples of what would be counted as large-scale processing, and also gives examples of what would not be large-scale processing. Of course, there is always going to be this grey area in the middle, but it does give some helpful hints as to the kinds of things that you need to think about. So, for example, the number of data subjects that you are processing, about the volume of data that you hold on those data subjects. So it's not just the absolute number of people, but the amount of data that you're holding about those people. But also things like the duration of the data processing, and also the geographic extent of the processing. So there's no definitive answer, but these are kind of things that you need to think about in order to determine whether you kind of fall into that category or not. But I do commend the DPO guidance from the Article 29 Working Group, and it's on their website, the EU website. Or if you get stuck, I'm sure that the good folks at Atos and Digital Guardian or myself can get you a copy.
Thank you. The next question. In general, how do you define being out of GDPR compliance? And follow-up to that is it just failing to disclose the breach within 72 hours, for example? Or is there a broader definition, such as, is it possible to state something like this machine is out of GDPR compliance?
Well, it's more complicated than that. So basically, you are out of compliance with GDPR when you are failing to adhere to any of the articles. So it's really, I'm glad this has been raised, because it's really important to understand that it's not just a breach. There are core principles in, I think, Article 4 that you need to adhere to. There are also a number of rights, so things like the right to be forgotten, the right to access, the right to rectification, the capturing of consent, those kind of things as well. Records of processing, so if you don't actually record what data processing you are doing, and this is like pretty fundamental stuff, that in itself is an area of non-compliance. So it is mainly about process for sure you can put some technical controls around that, and Zeina did a really good job of saying how you might do that. But it's important to understand that this isn't just about preventing data breaches. There's a lot more in there, and all of that would count as compliance. And so any area which you are not adhering to, so for example, if you do not have a records of processing, if you cannot service a subject access request and a bunch of other things, then that also means that you're out of compliance. So it's not as simple as a laptop is out of compliance. GDPR doesn't quite work that way.
Thank you. The next question we have is a compliance officer in a conflict of interest for the role of DPO.
Yep, so I can answer that. Well, I suppose the answer is it depends. It depends on the role of the compliance officer and whether they are the most appropriate person to perform the function. The test is this. Are they making decisions on the nature and purposes and means of data processing of personal data? If yes, then there's a conflict of interest. If no, then there isn't, and that person would be suitable for holding the DPO role. So that's kind of the broad test. But again, I would go back to the guidance issued by the Article 29 Working Group, because they are quite concerned about this area. So, but the broad test is if you determine or help to determine the purposes and means of data processing, then that probably would mean a conflict of interest. That's the acid test.
Thank you. The next question we have is several attorneys here in the U.S. have raised the question of what jurisdictional means the EU would use to impose fines on companies not based in the EU. What do we know about this topic presently?
Yeah, we know quite a lot actually. So although it's quite a complicated area as you might imagine, I mean the short answer is that most companies worldwide will try to operate within the law that pertains, and so there's kind of an incentive to do the right thing. So I think that's going to drive behaviour. Certainly, if you have a presence in the EU, then that presence will be the means of enforcement by a regulator in the EU. If you don't have a formal presence, then you are required to have essentially an agent in the EU, and again, that's the mechanism for enforcement. I mean, ultimately, if you are ignoring GDPR, you're in the US and you think you can escape jurisdiction, but you're doing substantial processing of EU data, they will essentially try to shut you down in terms of your operation in the EU. Of course, the other aspect of that is, do EU citizens want to share their data with an organisation that is egregiously non-compliant with data protection laws? So that's kind of a market-led initiative. And there are other things, a lot of other mechanisms around. So, for example, EU-US Privacy Shield, which is a mechanism for doing data transfers from the EU to the US. So if your data center is in the US, for example, and that's where you're doing the processing, you need a special dispensation to export data to the US. There's plenty of mechanisms to do that. Privacy Shield is one. The recourse that was introduced into Privacy Shield last year includes the ability to enforce data protection through the FTC and to allow data subjects or companies to take recourse in American courts. So there are a variety of mechanisms for enforcement. But I think my sense is that companies operating and are wanting to operate legally and processing EU-based data will try to comply because that's the right thing to do. But there are enforcement measures in place. None of which have been tested in court, of course. So, that a court case may come at some point.
Thank you, Duncan, and sorry for cutting you off. The next question we have is concerning the DPO in the context of nonprofit. What is considered large-scale processing?
Oh, I think we answered that one earlier on.
My apologies. The next question, in terms of showing DPO expertise, what certifications, qualification, or professional membership do you suggest as good evidence?
Yeah, Zeina, I don't know what you're seeing in the market in terms of DPO certifications.
So today there are no, let's say, a program, a certification like the CISSP for security. However, there are a lot of programs that is being done by organizations that specialize in data privacy or, let's say, legal support in order to help these persons that will be assigned to this DPO role into being able to have the expertise, because if you remember in Article 37, they describe the roles of this person. This person should not come only from a technical background and also should not come only from a legal background. So it should be a person that will be able to manage both, be able to understand the legal ecosystem as well as the technical environment. So there are some training that are being put in place to help people into grasping this role.
Yeah, absolutely. I just follow on with that. So the International Association of Privacy Professionals is an organisation that I hear a lot of, and so that is a professional association. It's a not-for-profit organisation, so they are doing some good work. Interestingly, 2/3 of their members have legal training, which I guess you might expect. But importantly, that means that 1/3 don't have legal training and come from all sorts of other backgrounds. And so it's not essential that you are have a legal training. In fact, just what Zeina has said, you need to have both legal and technical understanding as well. But you might want to look at the International Association of Privacy Professionals as a good starting point.
Thank you both. The next question, what are the differences between DPIA and the regular in-depth assessment?
Yeah, so the DPIA is really concerned with personal data and respecting the privacy of personal data. So you can consider it as a risk assessment, but really assessing the risk to the rights and freedoms of the constituents, the data subjects, and also about the risk that falls into putting in jeopardy these data. So we really need to understand, because I think there was another question as well that was saying should we only conduct the DPIA to processing of sensitive data or all processing? This is where it's important. We're talking about personal data. So the data that actually refers to an individual, we need to make sure when we run this assessment, how is this data secured? What are the risks that fall on this data? For instance, maybe there might be some technical shortcomings or vulnerability that would say this data could then be accessed by anyone and not by only the authorized people. And this is where we're talking about risk to this personal data. You should always keep in mind, the confidentiality, integrity, and availability of these personal data, and run the risk assessment and the DPIA with that in mind. And also, the Working Group 29 had a very interesting document that explains when the DPIA should be done, how it should be carried out, and I also recommend people to check it.
Thank you. The last question we have, you refer to companies. What about higher education institutions?
Oh, yeah, it's there is no escape, I'm afraid. Yes, so we've referred to companies as a shorthand, but clearly this applies to any any entity, including individuals, public authority, agency, any other body, determines the purposes and means of processing. So any individual or organization or construct that is determining the means and purposes of data processing defines themselves as a controller, and I'm afraid you're in.
Thank you very much. This is all the time we have today for questions. If you enjoyed today's webinar, don't forget to register for our upcoming webinar, WannaCry Ransomware, Are You Safe from the Dangers of Ransomware? This will be on Thursday, June 15th at 11 a.m. Eastern Time. You can register for this through our webinar page on our website at www.digitalguardian.com. Finally, both the slides, recording, and a copy of the IDC report will be sent to you via email. I'd like to thank both Duncan Brown from IDC and Zeina Zakhour from Atos and our audience for joining us today. Have a great rest of the day.